Damien Geradin, welcome to Digital Markets Research Hub. As always, a great pleasure to seeing you. I wanted to use this opportunity to learn from your experience and about your views as an academic, because you've been always for many years the person who channels the discussion, who manages to put together things in a very clear, logical, and very thought-provoking fashion. But recently, relatively recently, you have also become a very visible and impactful practitioner. I want to use this type of your competence as well and to learn from your practice and experience. But I propose to start with the academic one.
Sure.
We live in a very kaleidoscopic time. Things are changing very quickly. The views about the very nature of competition law, economics, and policy are also rapidly evolving. Please provide to us your outline of the latest development in competition law and policy and the repercussion of these developments on the theory of competition law.
So thanks a lot for having me. I'm always glad to talk to you, Olesh. It's a privilege. So yes, I mean, I think that over the years, I've been sort of at the forefront of some interesting developments. You know, I started my career very much focusing on network industries and the liberalization of telecoms, of energy, postal markets, and so on and so forth. That kept me busy for 10 years, academically and to a less extent at the time as a practitioner. And then I got really excited and interested in intellectual property. There were lots of very interesting cases about standard essential patents, and it's another topic that kept me busy for 10 years. And then more recently, as you know, I got really interested into platforms. And I think, perhaps immodestly, I was one of the first one to see that there was a real subject there, you know, about 10 years ago. And indeed, it became a major area in terms of competition development, legislative development with the DMA and the DMCC. A lot of very interesting academic work has been done on the economic side and then on the legal side. So yes, I mean, these have been very interesting developments over the past 30 years. There have been other things as well. But these three, I think, were really quite interesting. And I think that what is, you know, really interesting is that, and I'm working on a paper where I'm trying to tie different things together, is that we always deal with similar issues, right? And let me explain. If you look at the DMA and the competition cases we've seen in digital markets, they raise the very same issues that were raised 25 years ago with network industries, which is that you have a dominant company and they will try to leverage their market power from one market to another, right? Vertical leveraging, which is something that we hear about almost every day, where, you know, you say Google is leveraging its market power in search to, you know, another market, for instance, or Amazon is leveraging its market power in e-commerce to another market. Well, that was the sort of theories of on that were at the core of competition cases in the 1980s and 1990s. And as in the digital platforms, eventually the European Commission decided to legislate and to regulate these corporations. And, you know, we've seen very many parallels. So this idea that self-preferencing is something totally new, I don't think so. I think it's the sort of topics that we dealt with already 20 or 30 years ago. If you look at another example at the moment, there are a lot of discussions about pricing, app store fees, for example. right? Well, these are the sort of issues we saw with standard essential patterns, where to some extent the SCP holders were gatekeepers. And then, to sort of constrain their ability to engage in abusive pricing, we imposed them then on a friend commitment. And the friend commitment is something that you see, in Article 12.6 of the DMA, with again the same sort of thinking. Apple and Google are gatekeepers, and their app store fees are probably on the high side. And what can we do to constrain them? Right? What you do is to impose a friend commitment. So what I'm saying is that what is fascinating about competition law and regulation is that very often the new things are a continuation of the old things. And what is nice when you have 25 or 30 years of experience is that you're rediscovering old problems all the time, and you can to some extent reuse the same solution, or at least the learnings of the past, right? So when we say that there are a lot of new development, it's true. But the core problems, especially those that relate to market power, are very often, new iterations of things that we've seen a long time ago. So, and I think there are great benefits, instead of reinventing the wheel, to look back and say, okay, we've gone through these problems before, right? I mean, again, if you think about market power and fees, credit cards, right? I mean, it's another area where you had companies charging very high fees, and eventually this was dealt with through regulation. So I would invite, especially young academics, to sometimes look a little bit in the past. Maybe I'm saying this because I'm not so young anymore, but I think there's a lot of value in looking at other areas. And I think also that one of the things I've over tried to do is to look at things laterally, right? Instead of, you know, putting myself in a tunnel where you just focus on one issue and you're not looking at other things, right? One of the things that I wrote about 20 years ago, I wrote a book called Market Power in Telecoms. It was published by Cambridge University Press, and I wrote it with an economist, a friend of mine. He's now at the World Bank. And, again, the topic was to tackle market power, in an industry where you had some very strong gatekeepers at the time. I don't think telecoms companies are, are really the big gatekeepers these days. I think many of them are incredibly weakened. And, again, we thought about tools. And, the book is about a combination of competition law and regulation. So 25 years ago, to address market power issues in areas where you had very strong gatekeepers, we were already looking at the combination and the interface between competition and regulation. So when people are talking about ex-ante regulation as if it was a new invention, not at all. I mean, already 25 years ago and probably earlier, even this was the sort of combination of tools we were thinking about.
Okay, but let us then look at the mechanics of things.
Yeah.
Obviously this new wave of enthusiasm about recalibrating competition in digital markets presupposes and leads to an expectation of more proactive engagement of competition agencies in not only protecting competitions, but maybe even promoting or tailoring, shaping competition in digital markets. How do you see this journey? Do you think that it is ultra virus for the DMA, for the DNA of competition authorities? Do you think they know how to do it? Do you think they are even interested of doing it? And do you think they will face a huge opposition from those who would be regulatees, and also people who say that it is beyond the mandate of competition policy in the traditional canonical interpretation, particularly nowadays when things become so geo-economically sensitive.
Yeah. I mean, I think, look, I think competition policy has been challenged in the digital market space for several reasons that were already identified by the Furman Commission almost 10 years ago, which is that you have companies that are incredibly strong, right? That move fast. Let's not forget the move fast and break things, sort of motto of some of these companies. Whereas you have tools that are sort of slow and burdensome, right? And it's true, and it's frustratingly true. Very often, you have companies coming to me and they say, okay, we've got this problem with Google or with Apple and things like that. And then what can we do? We need a quick solution. And there's no quick solution to offer, because you can file a complaint to the European Commission, and then it's going to take some time for them to process it. And then, okay, you can try, to obtain interim measures, but it's very, very rare. The test is very demanding. And then very often it takes years to get an outcome. And so that is a problem. That is a very, very, very big problem. And it's also true in litigation. If you decide to litigate against these companies, well, it takes forever. More recently, I've been pretty heavily involved in litigation before the Competition Appeals Tribunal, and it's enormously costly and tedious, right? So speed is an issue, a critical issue. And so I think that the European Commission and the UK government had to be innovative, right? And then they said, okay, let's try to put together a tool that will be faster. And that's the DMA and the DMCC. But let's focus on the DMA. And the DMA has been criticized on various grounds, right? But it is effective. I mean, look, if you see that already Apple and Meta have been subject to infringement decisions, and there will be more infringement decisions, including most likely another one against Apple in a couple of months' time, right? Or sooner than that. You see that you're talking about something that moves faster, and it's great. And I know that these companies are very difficult nuts to crack, right? And they resist, and they have lots of resources and excellent lawyers, and they can use all the processes to make things difficult. But there comes a moment where they have no choice but to implement. And I think we're reaching that point, especially for Google and Apple, which were the prime targets, Meta to some extent, the prime targets of the European Commission. So I think we've already, made steps in the right direction. It's not perfect. Now, one mistake, in my view, of the DMA, and I said it many times, is that the European Commission has the exclusive competence. And the problem with that is that it's a bottleneck, right? They have only limited resources. They don't have the people they need, right? I mean, those there work very hard. They're very motivated, but look, there's so many problems, and these cases are so complicated that you need more bodies, basically. And we've seen in competition law that some of the competition authorities have been doing great work. The French Competition Authority, the Bundeskartellamt, the ACM in the Netherlands, the Italian Competition Authority, and others have done very important cases. And the quality of what they've done is not bad. I think some of the decisions are remarkable decisions. And so I would have liked them to play a bigger role in the DMA than simply being assistants of the Commission, which is not a very appealing thing, right? Now, there is another, of course, enforcer, the courts, and the DMA's direct effect, which is important. And we have not seen a lot of DMA litigation, but I suspect it will come. I think that if some issues are not addressed by the European Commission, they will be businesses that will think about litigation. And I think some courts will become natural courts, right? Courts that can give injunctions, for example, right? It's a powerful tool, right? And so although we have to be realistic, and we will always be disappointed in some ways, I think the DMA is starting to deliver.
On the mechanics of the DMA delivering, some people say that the more enforcement we see, the better, because it's kind of bottom-up approach. The more cases, even if they are not comprehensive, cumulatively they contribute to each other, and we have incremental improvements. Others say it would be better to do it in the ideal world on a top-down level, where the Commission would use variety of techniques, with litigation being almost a matter of not last resort, but kind of at the end of the priority list, and at the bottom and the top of the priority list would be an attempt to crack this hard nut, as you describe it, by means of regulatory dialogue, where you engage in something which is not very visible, but which can not very tangible, but which, if things go in the right order, can bring more factual improvements, or it's a completely naive approach? So which of the two do you support?
Well, I think that dialogue is good generally, but it's the history of the stick and the carrot, right? I mean, I think you need both. And that's why I believe that enforcement decisions are usually helpful. You need to create a case law. And of course, these decisions can be appealed and some of them will be struck down, right? So I think it's important to have enforcement tools that you apply, because otherwise there will be no dialogue, right? I mean, you need to have a way to pressure companies. And I think that the European Commission should not fear of losing, right? I've always said that it's perfectly fine for a public authority to lose in court, right? You cannot win every case. And it's even worrying when a competition authority or a regulator wins every case, because it can either mean that the system is rigged or that they only do easy cases, those they can win. So I think it's important to do many cases and test the limits of the law. Of course, there must be due process, and then it goes to the EU courts, and they can decide whether these decisions stick or not. Of course, when I say it's important to have enforcement, it should not be harassment either, right? They should pursue cases that make sense instead of frivolous cases. That's fairly obvious.
Before looking at the DMA in more detail, I wanted to ask you a question about the DMCC.
Yes.
You've been involved very in detail into this legislative process. The House of Lords Select Committee is making several very detailed contributions alongside with other peers, and the legislation is there, but we see that if agility was one of the main objectives, it's in the current regime, we are now stuck with designation. There will be tailoring obligations. So that some people start questioning whether it will be very suitable means to regulate competition in digital markets if every procedural step requires public consultation, and it's kind of
Yeah,
extended
I
environment.
think, look, I mean, I've always admired UK institutions, always. But there is a tendency of overdoing things, right? I mean, so the amount of consultation is just crazy, right? Um, and in the lead up to the DMCC, there was consultation on the, it's just ridiculous in the end, right? So, and it's the same with litigation. At the Competition Appeal Tribunal, it's very heavy, very burdensome, right? And to some extent, I like it because it's quality, right? You have plenty of space to expose your arguments, and the trials are very serious affairs. But again, there's a tension between something that is, high quality and something that is effective. So also in the UK, it's difficult to read the government because at the same time, they keep giving assurances that, the CMA should be independent and it's important they do their work and everything. But, there's also a temptation to be very friendly to big tech because, big tech can promise creating jobs and spending money and so on and so forth. So I think the DMCC, the main virtue of the DMCC, I believe, and if you look at things purely academically, okay, the DMCC is probably a better piece of legislation than the DMA because it allows to do things that are more bespoke, right? One criticism of the DMA is that you've got a rigid set of rules that apply to all gatekeepers independently of their business model, right? So, of course, some of the obligations only target some gatekeepers, but you could say it's too rigid. I mean, now the CMA will have the tools to do bespoke codes of conduct. But again, how many years will it take to get there, right? I mean, first you have to designate the gatekeepers, and this will be a contentious process, I'm sure. And then there will be probably consultations over the codes of conduct and so on. So, I mean, I like the idea of codes of conduct, right? But I would like them to be quickly adopted instead of going through years of discussions.
And we also have efficiency defense in the DMCC, which is another year
You
of,
you you do now. Efficiency defenses have not always been very successful, as you know, right? But still, it's one more thing. And then litigation, to the extent there is litigation, is quite burdensome. And it ties up a lot of resources within the agency. So look, I'm reasonably optimistic, and I hope they will succeed. But again, time is of the essence. And that, to be honest, that's been one of the great things with the DMA is that it was quickly put together and it was quickly adopted and it's been quickly enforced. With the Commission at the moment trying to stick to the 12 months, period to adopt a decision. So I think that's one of the great merits of the tool.
let us talk about it in more detail. So it not only in contrast to the DMCCA, the DMA is up and running, but also some people start already doing some taxonomy and periodization of the DMAs. Second year of compliance reports and compliance non-confidential summaries available for all of us. We can maybe somehow comment on the evolution of the DMA. How do you see this evolutionary process?
I think the DMA is functioning at the moment. We'll see, of course, what happens when the decisions are appealed, and some of the decisions will be appealed, right? I mean, already some of the gatekeepers have decided to appeal these decisions, and I think the tool will evolve and should evolve in the sense that I think we're already seeing gaps in the DMA. And one of the things that could be dealt with through case law is that some of the provisions are a bit ambiguous, right? They can be read in different ways. And so, for example, one of the things I'm telling to my colleagues in London that deal with the DMCC, because I have a colleague, Tom Smith, who's much closer to this than I am, is that it's very important that the codes of conduct be quite specific, because as soon as introduce language that can be interpreted in different ways, it creates difficulties, right? I mean, if you look, for example, at Article 5.4 of the DMA, which is, a provision that has been enforced against Apple to the extent it deals with steering. Well, 5.4 can be read in different ways, right? I mean, in the case of steering, is it possible for Apple to charge a fee, for example? Which kind of fee? That's not very clear, right? And obviously, I think, first of all, we haven't seen the decision of the Commission. It's not been published yet, and I'm really looking forward to see, what's in it. And then I suppose there will be an appeal at the General Court, and maybe the appeal will also clarify some of the language. So I think that there will be, of course, clarification of the language through the case law, well, through the decisional practice of the Commission and the case law. And some of the things that are not clear today might become clearer tomorrow. That's my hope. But I don't think you can only bank on the decision-making process, the decisional practice of the Commission and the case law, because you see that, there are enforcement efforts, but at the moment there are very few investigations, right? And there's probably many needs of clarification. And already some people are saying, well, AI is missing, whereas AI is the big thing, right? So what does it mean in practice? Do we need to integrate, existing or future AI gatekeepers into the tool? I don't know. Maybe it's too early to tell. But I think it must be a living document, the DMA. Let's not keep it as it is for the next 15 years. I think it should be revised at some point, or there should be interpretative guidelines. I think it's important to, further specify what some of these provisions.
You also, among other things, Damian, have an opportunity to communicate with different representatives of different business users. Obviously, the DMA is not only enforcement. The very fact of its existence could have some repercussions on the structure, architecture of some core platform services and some digital markets. How do you see, are there any beneficiaries and any benefits in terms of business users or maybe some horizontal newcomers in some specific core platform services? Can you say that the DMA has delivered already some measurable or tangible outcomes already in year one or year two?
I mean, look, first of all, I think we'll know better when we see the first decisions. Okay, because, for example, we know that the first decision against Apple on steering is an important one, but we haven't seen the decision. So I think, whether or not this will deliver depends a little bit on the way, on what's in the decision, because I've already received, dozens of questions from app developers saying, what does it mean in practice? How does this work? Right? What does it mean concretely? And I'm telling them, well, this is what I think, but let's see what the decision says, right? For example, there's nothing about the fee. Fee is important because if you charge a fee, you may make it unattractive. Friction is also important. But yes, I mean, already you see that Apple and Google have made some moves. It's not perfect, obviously, but it will take a bit of time. But also, I think we need to see things in combination, right? If you think about the App Store, which is, of course, an important platform, which is very contentious, as you know. Look, you see that some things have happened in the US with the Epic Games versus Apple litigation. And I think it's moving the needle, right? So I don't think one tool will deliver, but I think what's going to happen, and I hope it will happen, is that there will be a moment where some of these companies will need to do something big, right? Let me give you an example where I think this will happen. Okay. I tend to be optimistic in nature, otherwise I wouldn't do anything, right? Because the hurdles are enormous, right? It takes a lot of efforts and determination to achieve anything. But if you look at ad tech, which is a subject I got interested in 8 years ago, 8 years ago, nobody knew what it was. Nobody, right? And I was visiting regulators with one client, and they were literally staring at us saying, Jesus, that looks really, really complicated. And most of them were not really keen to do anything about it. But now, 7 or 8 years down the road, we've got a decision from the French Competition Authority. We've got a very important judgment, in the US, Eastern Virginia, which could lead to structural remedies. The remedies trial will start on the 22nd of September. There's a European Commission decision in the pipeline. You've got also an investigation, the CMA, investigations in other parts of the world. You have damages litigation in the UK, in the Netherlands, in Germany, in Australia, in Canada, in the United States. So I think we're reaching a point where Google's situation is untenable, right? They will have to do something. I don't know what they will do, but it's the combination of all of this, the combination of several tools, competition law, to some extent regulation, private litigation, that creates the sort of pressure where, as happened to Microsoft 20 years ago, they need to do something, right? There will be someone in the board of these companies at some point that might say, look, we need to do better because of the reputational damage, because of the cost, because of the management distraction. It's not funny for executives to be cross-examined in court, right? I think the reason why it's not happening is because the profits that are made in the meantime are enormous, right? I mean, it's just, if you look at ad tech, it's still generating piles of cash, right? So there's an incentive to carry on as long as possible. But I think the same will happen with again, with app stores. You've got competition cases, you have the DMA, you will have the DMCC. There's, I think, a new bill in the United States. You have things moving in other jurisdiction. There is private litigation. And so there comes a point where it becomes untenable. Denying everything and fighting everything. I don't think it's a long-term strategy.
I must echo the point about EdTech, and I think your papers were really, really eye-opening for, at least for competition people, competition law community. Some of them have been co-authored with Dimitris Katsifis, I think.
Yeah, I know,
With him
absolutely.
separately. It was
Yeah,
really, really impressive. I want to revert to private enforcement in more detail in
sure.
digital markets cases. Obviously, there is a comprehensive outline of the typology of private enforcement in digital markets, which you have provided in a very clear, approachable, and deep fashion in your, I think it's lecture or presentation at Mannheim Center for Competition and Innovation. It's called
Yes,
Antitrust
yes.
Damages Actions Against Digital Gatekeepers, a fantastic piece available on YouTube, so I cannot recommend more. But I wanted maybe to pick some of these points and maybe to ask you more specifically on private enforcement. Namely, you mentioned in passing about the DMA that we are still not we will have to see cases. Do you think it
Yes.
will be follow on or standalone cases mainly?
I think it will be both. I mean, I can see different types of DMA litigation. I think that you will have a company frustrated by the lack of enforcement, going to court and asking the court to implement Article X of the DMA, right? And seeking an injunction, for example. But then, and that is the tool, let's say, to basically enforce the provision. But it could be combined with damages, right? And you can also have pure damages action. For example, if some of the App Store provisions or some of the provisions that apply to search are not complied with, and they're not complied with for several years, right? I mean, you would have a damages action, on the ground that the DMA has been violated, and this created harm for either consumers or business users. You can have also hybrid actions, which could be partly based on competition law for the past, for example, and the DMA for the most recent time, right? So I think that DMA litigation has a lot of future. And obviously this is something I'm looking into. And I think you need to be a little bit creative to build these cases. These are cases that are difficult to build because you need to either find clients that are willing, to do it, or you need funders that are willing to fund these cases. But I think we'll see quite a lot of them. At the moment, you don't see that many damages cases because it's very recent, right? So the sort of, length of the infringement period is not long enough. But I think that in case of lack of enforcement for several years, then it will become quite attractive, especially if you can also combine it with competition law.
And which EU jurisdiction would be? Should we expect some surprises, or it will be traditionally?
No, I mean, again, I think it's very, very new. And obviously, you would need courts that are competent, good quality courts with good judges that are reasonably quick, and in jurisdiction where you can get damages if this is what you're after. But I think if you think strictly in terms of ensuring compliance with a given provision, then I think indeed you need competent court. Quick is important. Whether you can get an injunction is important, and so on. And so I think that practitioners will have to do, a bit of market testing, and think carefully about that. That's why, in my firm, we decided to have offices in different jurisdictions, because then we can always look at options. Yeah, and there's also the time frame, which is critical, and the cost. Okay. And then I think that over time, some jurisdictions will become appealing.
If we can access a little bit the kitchen, so to say, and if I can ask you a question about your observation, how defendants, they obviously also consolidate their experience and expertise, and their muscles are getting stronger. They know how to respond. So which typical strategies can we observe a typical defense strategies, leaving aside case by case specificity, factual specificity? Are these strategies eye-opening for you, or quite predictable continuation of what they do in ex post competition law?
No, I think the strategies, is to delay and deny. So, I mean, you will try to slow things down. And how can you slow things down? Well, you can challenge jurisdiction. You can challenge, if there is funding, you can challenge the funding agreement. We've seen that in the UK recently, where suddenly there is a lot of attention to funding, which is not necessarily a bad thing, but you know, it takes time. And then, yeah, so it's really a sort of delay and deny. And they have very, very good law firms, which are specialized in that sort of business, right? In the UK, you always see the same firms on the defendant side, and they always use the same tools. I think also that one of the important things is that claimants are always on a tight budget. Defendants are not. I mean, I suppose they have a budget. It's not as if they're willing to throw money through the windows. But I think, you know, there are difficulties. One is that, you know, you want to go quick, they want to go slow. You have a budget, they don't have one. You have very little information, they have all the information. So it's a bit of an asymmetrical fight, if you see what I mean. And so it's not so easy to win these cases. And we've seen some cases crashing, right? Um, and yeah, so it requires a lot of thinking and determination if you want to win these cases. And it's true that these companies, of course, they also learn on how to defend themselves, and they're pretty good at it.
On third-party funding, you again in that presentation you have said a lot which makes sense and explain the very rationale of it. But can you comment on people who say that this can be seen as a kind of overly commercialization and rent-seeking endeavor, which is the only way for claimants to bring at least relative parity in terms of resources, and but yet some say and observe that it's more a kind of litigation business rather than restoring justice or whatever it means.
Yeah, totally. So look, I mean, I think that in all industries, you've got good actors and bad actors, and you have excesses. Okay. The first point I would like to say is that it's not easy to obtain funding. It's very hard. It's a long-term process, and you're literally bombarded with hundreds of questions, right? And these funders typically they use. In the UK, they will use cases. On the continent, they have advisory boards that will literally look at every possible angle. So most frivolous cases are weeded out, especially because unlike in the US, you cannot do contingency cases in most jurisdictions, right? So this idea that you have law firms, basically you're working for free in the expectation that there will be a big payout at the end is not something we see. Now, which is good. Secondly, it's of course a commercial activity, and you need a big return if you win, because first of all, you need to put money on the table. Secondly, these cases take a long time. Thirdly, they're difficult to win. And so obviously, if you're willing to spend, let's say, 20 million on a case, you will expect a 4x or a 5x return. Now, in their defense, big tech companies are always saying, oh, this is commercial, this is too much, the returns are too high. They make me laugh, because when we speak about high returns, right, and the sort of opportunistic ways of making money, I mean, they're the first ones that should look at themselves, right? So I think funding is critical. And if you don't have funding, you don't have cases. Now, of course, funding needs to be looked at. And this is what the UK courts and the Dutch courts do. Don't think for a minute that the courts will allow, you know, crazy funding agreements. And by the way, in UK courts, whatever return you obtain, is subject to the courts, right? So if you have a funding agreement where you seek a 20x multiple, you can have it, but the court is very unlikely to give you that sort of return. They may say 4x is good enough. So it's true that it's a commercial activity, but I think it's a helpful commercial activity in that it sort of, create a better equilibrium between the parties, in that, very good law firms, which are well-resourced with people who know what they're doing, will have the resources to do a case against big companies that are very well-resourced with very good law firms. And, if you cut funding, these cases disappear, or they will be done by dodgy firms willing to work on the cheap without the proper resources and so on. So I'm a big fan of funding, you may say, because you benefit of it. Of course I do, but you have to realize that without funding, this is not happening.
And in this line, the role of settlement mechanism.
Yeah, so I mean, there have been few settlement agreements. The regime is quite new, and people tend to forget that, but it's a regime that is barely 10 years old. I think settlements are an important feature, of course, because obviously these companies will try to settle these cases, and I think for the funders, it's also a good exit strategy, a settlement. Now, it depends a little bit of the regime. For example, in the UK regime, it is the class representative, that will have to take a decision. And the decision can be informed in several ways, but never forget that the class representative acts in the interest of the class. And so it is not for the funder or for the law firm to tell the class representative what they should do. Of course, they can take advice, and of course, they will listen to suggestions that are made. But at the end of the day, it is for the class representative to get the best possible deal for the class. These settlements have to be approved by the court. So once again, there are gateways that you may not necessarily see elsewhere. Again, in the US, very often, these cases are funded by lawyers, and they can settle quickly to make a quick buck. Here, if you look at the UK, if the claim is like $1 billion, I don't think the class rep will be willing to agree on a 50 million settlement because it would not be in the best interest of the class. Now, you may have seen the Merrick's case, which settled for a tiny fraction of the claim value, at least the value that was attached to the claim initially. And it's, the judgment, the Merrick's judgment will come any day. And I think it will include a certain number of clues about funding, about settlement, and so on. It's going to be written by Peter Roth, who's an eminent judge in the UK. So I think the whole industry is sort of waiting to see what this judgment will say. So what I want to say is that, people tend to comment on all these issues, but there are lots of gateways, right? I mean, or guardrails, sorry, not gateways, guardrails, where, it's not as if we could do whatever we want. That's not reality.
I know we only have a few minutes left. Maybe you can mention the jurisdiction which appears to you the most attractive, the most well-suited and well-calibrated in terms of allowing private enforcement of competition and digital markets cases. And second question is recommendation to students. You observe so many practicing lawyers. Which skills are of the highest demands today and will continue being of demand tomorrow?
Yes. Let us finish with these two issues. I think that these are great issues. So, these regimes are relatively new, and there's a great deal of experimentation. Hmm? So where you go depends on a range of things. It depends on the sort of money you have to litigate, because the UK is very expensive. I think now 25 million pounds is what you need for a case before the Competition Appeals Tribunal. And there are very few funders who have the resources to fund that sort of thing. So it's a limitation in itself. Of course, if you litigate in the Netherlands or in France or Germany, you need much less money. There you can litigate with, 5 to 10 million. Then it depends on speed, because obviously it is a key consideration for funded cases. I mean, investors need a return not too long in the future. And I think they're increasing, worries about the length of these cases. So one of the things they say all the time is, how long will it take? And then you say, well, in the UK, it may be so many years. In the Netherlands, it may be so many years. In France, it may be so many years. And then it depends a little bit also where the harm was generated, whether you want to do an opt-out action or an opt-in action. Opt-out is only possible in the UK and in Portugal. Opt-in is possible everywhere. And so on. So I think, you could almost create a grid with, the features of each regime, and then decide based on the sort of money you have, where the victims are, speed, quality of the decisions, and so on. It's a multi-factor test.
Recommendations.
Recommendations for the students. So look, I mean, I think law is a great discipline. I didn't like it so much when I was at university, until such time I discovered economic law at the very end of my 5 law degree at the time, where I discovered IP law, competition law, European economic law. And then I decided, oh, that sounds interesting. This is maybe what I want to do. I think that people need to manage their careers in a way. And I think that I've always tried to manage things and to look long term, right? I think there are too many people who are just not strategic about what they do, in the sense that they will just go to one place because this is where you get the biggest salary, or because this is where you will look good when you speak to your friends, or this is the first firm to give you a contract or something like that. I think you really need to think carefully about what you do, because there are many law firms that give you a lot of money, but the work is very uninteresting, right? I mean, if you do private equity, is it really that exciting, this sort of line of work? Merger control only? Is this what you want to do with your life? There are also many law firms where the turnover in the staff is very high, where most people stay 2 years or 3 years and then they go. So my recommendation is always to look at the long term. Where will you learn more? What kind of people do you want to work with? And is being a legal practitioner something you want to do in the long run? And then once you have a strategy, it's important to build your brand. There are too many plain vanilla competition lawyers in the market. People, you don't know who they are, you don't know what they do. And I always encourage even the youngest people in my firm to write papers, to try to speak at public events, to have a bit of an academic activity on the side, so that people can recognize them, right? And if you look at the leaders of the profession today, people of my age, already 25 years ago, you knew them, right? So there are a lot of, private practitioners with an academic gig on the side, people with whom I disagree regularly, like Asimakis Komninos, for example, right? He tends to be on the other side of my cases, but he's high quality, right? I mean, he has a brand, he's very well known. Although we disagree, he's someone I can relate to because I think he has invested intellectually in the work he does, and he has great cases. And there are other people like that, right? There are many other people like that. Unfortunately, I think that people very often, they don't know what they want to do. They expect too much from others, right? They want to be entertained. They want to be assisted. No, that's not the way. You need to decide for yourself. You've got a brain, right? So, and take your decisions and look, be strategic, focus on the next 5 years or the next 10 years. That's the way to go.
Damien Geradin, thank you very much. Indeed,
Thank
for
you
this
so much.
fantastic conversation. It was a pleasure.
Thanks a lot.